Hello everyone, I'm Debojit Das and welcome to Courts This Week by LiveLaw. If you're trying to keep up with what's happening in courts across the country, here's a quick breakdown of the biggest developments from last week. From free speech and workplace dignity to bail, labor law and religious freedom. So without any further ado, let's begin. Kicking off this week, an order from the Uttarakhand High Court that's catching a lot of attention. The court has restrained Mohammad Deepak Kumar and others from posting videos or making statements online about the January 26th Kotdwar incident, observing that such content could affect the ongoing probe. So the context is that on January 26th, Deepak confronted Bajrang Dal members who were allegedly objecting to a Muslim shopkeeper using the word Baba in his shop name. A video of that incident went viral and multiple FIRs followed. One of them was against Deepak himself, accusing him of rioting, causing hurt and intentional insult to provoke a breach of peace. When the matter reached the High Court, Justice Rakesh Thapliyal orally reprimanded Deepak for repeatedly posting about the case, and as the court put it, sensationalizing the issue. The message was clear: if you've given the information to the police, let them do their job. The court refused to quash the FIR but directed the investigating agency to proceed strictly in line with the Arnesh Kumar guidelines. Deepak's counsel argued that he was actually trying to de-escalate the situation and the viral video wasn't released by him. He also claimed that despite identifying assailants, the police had acted against him instead. But the state countered this, saying Deepak was not cooperating with the investigation and that his public narrative did not match reality. The court ultimately said a person under investigation cannot seek protection through public messaging. If there are concerns, the proper route is to approach senior police officials. Now, the second story this past week, coming in from the Delhi High Court, which directed digital platform Newslaundry to take down certain remarks made against TV Today, which runs India Today and Aaj Tak. So what exactly triggered this? Newslaundry had used phrases like shit show and shit reporters and weed or opium to describe TV Today's content. The court said that this crosses the line. A division bench of Justice C. Harishankar and Justice Om Prakash Shukla held that these remarks amount to disparagement, and if they continue to stay online, they could cause serious and irreparable harm to TV Today. So for now, the court has stepped in and said, take these down. Not everything, but these specific statements have to go, at least until the case is finally decided. The dispute actually goes back to 2022 when TV Today filed a 2 crore rupee suit against Newslaundry, alleging defamation and copyright infringement across 75 videos. At that stage, a single judge had refused to grant an interim injunction, even though the court did say that there was a prima facie case and that the statements needed justification. So what we're seeing now is a middle path, not a complete gag on content, but a selective restriction on language the court sees as crossing into disparagement. But it does leave you thinking. In a space like media where criticism can be sharp, even uncomfortable because of its comic edge, can it be legally bound? And now the third story this week, and this one comes straight from within the judiciary itself. Are courts being too strict when it comes to bail? Supreme Court Judge Justice Ujjal Bhuyan seems to think so. Speaking at the Supreme Court Bar Association's National Conference 2026, Justice Bhuyan made a striking remark. He said some judges suffer from a more loyal than the king syndrome. In simple terms, he's pointing to a tendency within the judiciary to show excessive deference to investigating agencies. The result? Bail gets denied even in deserving cases, and people end up spending months, even years in jail. He didn't stop there though. Justice Bhuyan also flagged what he called a growing problem: the reckless registration of FIRs. According to him, cases are increasingly being filed for trivial issues: public demonstrations, student protests, even social media posts and memes. And naturally, many of these cases make their way up to the higher courts, with the Supreme Court often stepping in, sometimes even having to set up special investigative teams. All of this, he pointed out, consumes valuable judicial time. Addressing the constant criticism around case backlogs, Justice Bhuyan made it clear: the judiciary isn't the only one responsible. The executive, he says, plays a significant role through baseless FIRs and frivolous appeals. He also turned the spotlight on the UAPA, calling it a draconian law. And the numbers are hard to ignore. In 2019, nearly 2,000 arrests led to just 34 convictions. That's a conviction rate of less than 2%. In 2023, there were 2,941 arrests, but the conviction rate was only about 4%. He said this could indicate overuse of the law, where many arrests are being made without sufficient evidence. The alarm bells seem to be ringing as concerns about liberty, procedural hurdles, and accountability are being raised from the system itself. And now for the fourth story this week, a question before the Supreme Court that could have long-term consequences on labor policy in India. A 9-judge bench of the Supreme Court has reserved its judgment on whether the definition of industry laid down in the landmark Bangalore water supply case of 1978 needs reconsideration. If you want to access a quick summary of what the case is about, you will find a link in the description box which will lead you to a brief explainer on Instagram. Now, that judgment by Justice V.K. Krishna Iyer that introduced what's known as the triple test to determine what qualifies as an industry under the Industrial Disputes Act of 1947. And for decades, that definition has been considered by many to be extremely wide. But the government now says it's maybe too wide. Attorney General R. Venkatramani told the court that while the triple test is logically sound, it's been applied too broadly. His key argument: sovereign and welfare functions of the state should not be treated as industry. There were other concerns as well. Senior advocate Nafade argued that the original judgment wasn't even truly unanimous and pointed out that the definition itself was borrowed from Australian law. He also cautioned against applying any new ruling only prospectively, saying that would make the entire exercise pointless. Now that's where it gets interesting. The 2020 Labour Code actually retains Justice Iyer's triple test, but with important exclusions. It specifically keeps out charitable, social, philanthropic, and sovereign functions, something the original judgment did not do. On the other side, several senior lawyers, including Indira Jaisingh, Vijay Hansaria, and Gopal Shankar Narayan, strongly opposed narrowing this definition. Their argument is rooted in the idea that labour law is worker-centric, and tribunals under the 1947 Act were designed to give workers broader remedies than traditional courts. Senior advocate Jaina Kothari added another layer, calling for a purposive interpretation based on directive principles like Articles 38, 39, 42, and 43A. She also questioned whether the employer-employee relationship should even be the defining test for an industry. And then there was the argument that even charitable organizations involve labor, and that labor cannot be treated as charity. So what's at stake here is huge. The court's decision could redefine what counts as industry, so keep your eyes on this one. And now the fifth story this week, and this one could have a real impact on how the law treats parenting benefits. The Supreme Court has ushered in some important changes to maternity benefits and even opened the door for paternity leave in India. The case before the court challenged a provision in the Social Security Code 2020. Under that law, adoptive mothers were entitled to 12 weeks of maternity leave, but only if the child they adopted was less than 3 months old. The Supreme Court has now struck down that restriction. The judges said that this kind of age-based classification simply does not make sense. The need for maternal care does not suddenly disappear if a child is older than 3 months. Whether the child is 2 months old or 6 months old, the responsibilities of parenting remain the same. In fact, the court went a step further and called this provision illusory and devoid of practical application. It held that the restriction violates Articles 14 and 21 of the Constitution, that is the right to equality and the right to life and dignity. So what does this mean in practice? The court has now clarified that any woman who legally adopts a child will be entitled to 12 weeks of maternity leave from the date of the child is handed over to her, regardless of the child's age. But the judgment did not stop there. The court used this opportunity to make a significant observation on paternity leave. It urged the union government to consider bringing in a law that recognizes paternity leave as a social security benefit. The reasoning is a simple progressive realization that parenting is a shared responsibility, and the presence of both parents in a child's early life plays a crucial role in their development. So while the judgment directly expands rights of adoptive mothers, it also pushes the conversation forward towards a more equal and realistic understanding of parenting under the law. And for our next story this week, the Supreme Court refused to grant an adjournment sought by the state of West Bengal in a petition filed by the Enforcement Directorate. This case revolves around the ED's allegation that Chief Minister Mamata Banerjee interfered with its raid at the office of IPAC, the political consultancy linked to Trinamool Congress. At the very start of the hearing, senior advocate Shyam Diwan, appearing for the state, asked for more time to respond to a rejoinder affidavit filed by the ED. He argued that the rejoinder was not routine. It contained several new factual assertions that required a proper reply. Senior advocate Maneka Guruswamy also supported this request, but the ED strongly opposed any delay. Solicitor General Tushar Mehta pointed out that the rejoinder had been filed 4 weeks ago and said that this was simply a tactic to stall the proceedings. In fact, he remarked that if the state wanted to delay the matter, it should at least have a decent ground. The bench, comprising Justice Prashant Kumar Mishra and Justice N.V. Anjaria, did not seem convinced either. When Diwan suggested that the court could ignore the rejoinder if time wasn't granted, Justice Mishra responded with a sense of hostility. He even said, "Why should we ignore anything? You cannot dictate." At one point, Justice Mishra even remarked that a battle for adjournment was going on in the courtroom. Diwan then argued that the state was being put at a disadvantage and called the issue a sensitive matter requiring a detailed response. With the bench making it clear that the hearing would go on, the state then focused on its preliminary objection on whether the ED's petition is even maintainable. But the ED opposed that as well. saying all the issues should be considered together. And now a case that brings the focus back to dignity at workplace, as the Delhi High Court had to step in to protect a senior professor at Jamia Millia Islamia, and in the process delivered a strong message on how institutions should handle employee grievances. Justice Sanjeev Narola quashed disciplinary action initiated against Professor Sujata Aishwarya, who had raised a concern about access to a hygienic restroom on campus. So here's what happened. The professor had written to the registrar asking that a standalone restroom in her department be designated as a ladies' toilet. She cited hygiene concerns and also pointed out that she has a knee condition, making certain facilities difficult to use. But instead of addressing the issue, the university took objection to how the complaint was made, saying she did not follow the proper channel and used inappropriate language. What followed was a full-blown disciplinary process. A committee was set up and eventually she was directed to issue a written apology for alleged misconduct and insubordination. The High Court found this approach to be deeply problematic. It said a grievance about hygiene and dignity at the workspace, especially from a woman employee with a physical difficulty, cannot be trivialized or turn into a disciplinary issue. The court was clear. Procedural rules cannot become so rigid that they override basic concerns of dignity, hygiene, and humane working conditions. This was a complaint that required engagement, not escalation. In fact, the court said turning this into a demand for apology was plainly unsustainable and sent the wrong message, as if raising the grievance itself was a mistake. Calling the university's response deeply unfortunate and manifestly disproportionate, the court set aside the show cause notice, the committee proceedings, and the order directing an apology. It also directed the university to ensure that the professor has access to a hygienic and suitable restroom facility in the meantime. And now for the second last story this week, a powerful reminder from the Allahabad High Court on the scope of religious freedom that needs a frequent reminder these days, it seems. The court has made it clear that the constitution protects the right to congregate for worship. This came up in a petition filed by Munazir Khan, who alleged that the Uttar Pradesh administration was preventing him and others from offering namaz at a site where he claimed a mosque existed. He argued that especially during Ramzan, there cannot be any restriction on the number of people gathering to pray. In fact, during an earlier hearing on February 27th, the High Court had come down strongly on the administration, saying that maintaining law and order is the state's responsibility. The bench even remarked that if authorities like the Superintendent of Police or District Collector feel incapable of handling the situation, they should resign or seek a transfer. When the matter was taken up again, the state attempted to clarify that the earlier reference to a 20% restriction actually came from a misinterpretation by the Petitioners' Council, and that no such restriction was officially imposed. But the court did not accept this explanation. It pointed out that the earlier order was passed in open court with both sides present, and no objection had been raised at that time. Importantly, while disposing of this case, the bench of Justice Atul Sridharan and Justice Siddharth Nandan made a broader constitutional observation. It noted that congregational prayer is an essential feature of the Abrahamic faiths, and Article 25 does protect this right to gather for worship. At the same time, the court drew a clear line. This protection cannot be extended to activities that incite one religious group against another under the cover of prayer. The petition was ultimately disposed of, with the court directing that its order be circulated to the top state authorities, including the Director General of Police and the Additional Chief Secretary, so that it reaches even the lowest levels of law enforcement. A case that has been making quite some noise over the last week. And finally, for the last story this week, a ruling from the Karnataka High Court on privacy and access to financial records in matrimonial disputes. The court has said that one spouse cannot use the RTI Act to obtain the other spouse's income tax returns. According to the court, details disclosed in income tax filings all fall under personal information as per Section 8, subsection 1J of the RTI Act, and are therefore exempt from this disclosure. The argument before the court was that such information is necessary in maintenance cases, but the bench made it clear a dispute between spouses is still a private matter. It does not qualify as larger public interest, which is required to override this exemption. The court relied on the Supreme Court's ruling in Girish Ramchandra Deshpande versus CIC to support this view. At the same time, the judge clarified that this does not leave the spouse without options. If there is a maintenance case pending, the court hearing that case can call for financial records directly from the Income Tax Department to assess the financial position of both the parties, as per Section 138 of the Income Tax Act. So while the RTI route is closed, the legal process within the court remains open. In this case, the High Court partly allowed the petition and gave the wife liberty to approach the maintenance court, which can then summon the necessary documents as per law. And those were the key stories from courts this past week. If you want to access the detailed reports for all the cases mentioned here, visit livelaw.in and keep following us on all our socials to stay updated with everything that is law.